So a judge has found a Destiny 2 cheater legally liable for cheating, copyright infringement. But more interestingly, this time, it's also RICO. It's not normally RICO, as Popat likes to point at here. Thank you, Ken White. Now, RICO is an anti-organized crime law that's used to go after mobs and mafias. Rudy Giuliani indicted 11 organized crime figures, including the heads of the 5 families, all under the RICO statute. So that's where we are now today. Destiny 2 cheating has reached the level of organized crime, almost. Maybe it has. But the U.S. District Court for the Western District of Washington has decided in a default judgment that a Destiny 2 cheater has some kind of legal liability for their cheating. So join me as we look at the judge's decision and see what happened here. This is Bungie versus Elite Boss Tech, is how the case will show up in case search engines. But today we're concerned with Daniel Fagerberg Larson. This matter comes before the court on plaintiff's motion for default judgment. Having reviewed the motion and all supporting materials, the court grants the motion, enters default judgment, and enters a permanent injunction against Larson on the terms set forth in this order. Operating out of Bellevue, Washington, Bungie develops, distributes, and owns intellectual property rights to a video game called Destiny 2. Bungie alleges Larson, a resident of Denmark, as well as others, Robert Nelson and Patrick Schaufus, developed, marketed, and sold cheat software for Destiny 2 through a website, wallhacks.com, that allowed users of Destiny 2 an unfair advantage when playing the game. The court refers to the cheat as the Wallhacks cheat and the business run by Larson, Nelson, and Schaufus as Wallhacks. Bungie alleges and has provided evidence that Larson helped develop the software code and framework of the Wallhacks cheat. Larson worked together with Nelson and Schaufus to develop, market, and sell the Wallhacks cheat to consumers around the world. Through a consent judgment, which means Nelson agreed to the judgment, he also agreed that the Wallhacks cheat had been downloaded about 6,800 times. Nelson also agreed that the Wallhacks cheat willfully violated Bungie's 2 copyrights associated with Destiny 2, and Nelson also agreed that the Wallhacks cheat circumvented the technological measures Bungie employs to control and limit access to its Destiny 2 software, such that each download of the cheat constituted a violation of the Digital Millennium Copyright Act, Section 1201. The parties agreed that the judgment should be entered in the amount of $13.5 million, representing statutory damages of $2,000 each for the 6,800 downloads. Defendants consented to the entry of a broad permanent injunction, and Bungie withdrew all other claims. Now, the remaining claims are against Larson. 1. Copyright infringement. 2. Violations of the Civil Racketeer Influenced and Corrupt Organizations Act, RICO. 3. Violations of the DMCA. 4. Violations of the Computer Fraud and Abuse Act. 5. Breach of contract. 6. Intentional interference with contractual relations. 7. Violations of the Washington Consumer Protection Act. And 8, because my voice can't get any higher, civil conspiracy. Bungie seeks entry of a default judgment on all claims, asking for a judgment to be entered in the amount of $17,278,305.73. This represents the sum of the statutory damages above, $13.5 million, $466,700 as damages for its copyright claim, trebled or multiplied by 3 to $1.4 million. Then, get this, $666,666 in actual damages, measurable actual damages for its breach of contract, RICO, CFAA, and CPA claims, which Bungie asks to be trebled to $1,999,998. Could have just rounded that to $2 million. Plus $267,887 in attorney's fees and $80,000 in costs. Man, that was not a cheap lawsuit. Bungie asks for an entry of a permanent injunction, barring Larson from engaging in future and further conduct that forms the basis of its claims in this action. So how did we get here? There's a default judgment. Why are we allowed to have a default judgment? Don't you just automatically win your court case if the other party doesn't show up? No, well, at least not in federal copyright court. So Larson might not have appeared in court, but he would have been properly served. So he had notice of the lawsuit, of the action, and thereafter did not respond. And still, Bungie has to prove their case, though. The judge is going to hold Bungie to a particular standard, and that's what we're going over now. After the entry of a default, the court may enter a default judgment. The determination is discretionary. Factors which may be considered by the court are the possibility of prejudice to the plaintiff, the merits of plaintiff's claim, the sufficiency of the complaint, the sum of money at stake, the possibility of a dispute, whether the default was due to neglect or excusable neglect, the strong policy underlying the federal rules of civil procedure favoring decisions on the merits, so we don't like default judgments. The general rule is that well-pled allegations in the complaint regarding liability are deemed true, and the district court is not required to make further detailed findings of fact, so no further investigation for unnecessary details necessary by the court. Now, how do we have jurisdiction over Mr. Larson? Turns out Mr. Larson is not in the U.S. Well, first, the court has jurisdiction over Bungie's claims because those are federal laws, those are copyright, we're in the right court, we're in the right state, I guess. So that's subject matter jurisdiction and supplemental jurisdiction for the state court claims, but there's also the matter of personal jurisdiction. You need both. You need to have both subject matter and personal jurisdiction. The court finds it has personal jurisdiction over Larson, a valid contractual forum selection clause to which defendant has consented. What does that mean? That means he signed their terms of service when he signed up for Destiny 2 or a Bungie account. So there's a valid contract between Larson and Bungie. Therefore, there is a forum selection clause. Bungie has provided evidence that Larson agreed to the terms of Bungie's limited software license agreement, which required Larson to agree to submit to personal jurisdiction of any federal or state court in King County, Washington. The court accepts as true that Larson agreed to these terms, given the well-pled allegations in the complaint. So because Larson did not respond, then the judge will assume those well-pled allegations are true. And the additional evidence submitted, supporting evidence, strongly suggests that Larson had to have agreed to the license agreement or terms in order to develop and refine the wallhacks cheat. Then there's the idle factors. What's idle? The idle factors assess whether default judgment should be entered and in what specific amounts. There are 7 idle factors that weigh in favor. I think those were the ones above. But the court finds that the judgment shall not be entered as to all claims or in the full amount that Bungie requests. So, factor 1, prejudice to the plaintiff, prejudice to Bungie. Without the entry of default judgment, Bungie will be prejudiced. Bungie has attempted to litigate this case and vindicate its rights under federal and state law against Larson and the other defendants. Bungie was able to settle its claims with Nelson and the corporate entities he owns, which led to the entry of a consent judgment. But Larson has failed to appear or participate in this litigation despite being personally served, which means they literally handed him a copy of the lawsuit by an official witness who can report back to the court. A process server. You've been served. He was literally served. Bungie faces prejudice by not being able to obtain complete relief on its claims against Larson without the entry of default judgment. This factor weighs in favor of granting default judgment. 2 and 3, the merits of Bungie's claims and the sufficiency of their complaint. So, do they establish copyright infringement? You must show ownership of a valid copyright and demonstrate that alleged infringers violate at least one of the rights granted in Section 106, the copyrights, like the right to control copies. And they can also prove willfulness. The defendant was aware of the infringing activity and the defendant's actions were the result of disregard, willful disregard, reckless disregard to the copyright holder's rights. Bungie has sufficiently alleged a meritorious claim for willful copyright infringement. Destiny 2 is copyrighted, Bungie has alleged and provided evidence that Larson was a partner in wallhacks and developed the wallhacks cheat, which directly infringed on Bungie's copyrighted works in various ways. And Bungie has provided cogent allegations and additional evidence that Larson's infringement was willful. The court finds entry of default on those claims is proper. But this is the one that I'm looking forward to, civil RICO. Bungie's well-pled complaint and supporting evidence establish Larson's liability under the civil RICO statute. To prevail on its RICO claim, Bungie must show 1. A violation of, the RICO statute, 18 U.S.C. section 1962. The court's going to go over that in a moment. Plus injury to its business or its property, and 3, causation of the injury by the violation. So I guess the violation is the big one. To prove a violation, Bungie must prove 1. Conduct, 2. Of an enterprise, 3. Through a pattern, 4. Of racketeering activity. These are the predicate acts. 5. Causing injury to plaintiff's business or property. Remember this, there will be a test later. Bungie has demonstrated sufficient allegations and evidence that Larson, Schofius, and Nelson operated the wallhacks business as an ongoing organization that acted as a continuing unit to help them develop and sell the wallhacks cheat. An enterprise includes any union or group of individuals associated in fact which can be proved by evidence of an ongoing organization, formal or informal, and by evidence that the various associates function as a continuing unit. Bungie has provided evidence that Larson conducted a key part of the enterprise by developing and refining the wallhacks cheat. Bungie has also shown that the wallhacks enterprise engaged in various predicate acts that injured Bungie's business. Specifically, Bungie has alleged and provided evidence that Larson and the enterprise engaged in criminal copyright infringement and money laundering in violation of the law. As to criminal copyright infringement, Bungie must demonstrate that Larson willfully infringed on a valid copyright for the purposes of commercial advantage or private financial gain. Here, the allegations and evidence suffice to show that Larson willfully accessed and utilized Bungie's Destiny 2 software in order to develop the wallhacks cheat, which directly infringed on Bungie's 2 valid copyrights for Larson's personal gain. The allegations and evidence are also sufficient to satisfy the predicate act of money laundering. A defendant engages in money laundering when they 1. Conduct or attempt to conduct 2. A financial transaction, 3. Knowing that the property involved in the financial transaction represents the proceeds of some unlawful activity, 4. With the intent to promote the carrying on of the specified unlawful activity, and 5. The property was in fact derived from a specified unlawful activity. Bungie has shown that Larson and the wallhacks enterprise obtained financial proceeds from the sale of the wallhacks cheat, which was the product of criminal copyright infringement. Bungie has shown a pattern of racketeering activity through the continuous operation of the wallhacks enterprise and over 6,000 downloads of the wallhacks cheat from at least 2019 through 2021. The court does not reach Bungie's allegations that these acts constituted wire fraud, as doing so is unnecessary, and the court has doubt as to whether such a claim is adequately pled. The rest of the RICO statute. The court finds that Bungie has demonstrated the violations of RICO. Larson received income from the wallhacks enterprise that was reinvested in the enterprise to develop as well as market new cheats, and Larson has an interest and control in the enterprise, and the enterprise is engaged in interstate or foreign commerce for the sole purpose of selling the wallhacks cheat. As to the final 2 elements of the RICO claim, Bungie has shown an injury to its business or property that was proximately caused by the wallhacks enterprise's conduct. To satisfy these elements, Bungie must show it has suffered a concrete financial loss by documenting the amount of damages to which it is entitled. Bungie has provided evidence that it has expended a minimum of $2 million on security staffing and software to address the fallout from the wallhacks cheat, and 2 other software cheats impacting the Destiny 2 game. In sum, the court is satisfied that Bungie has sufficiently alleged a violation of RICO. The court finds that entry of default judgment on those claims is proper. The DMCA. prohibits the circumvention of any technological measure that effectively controls access to a protected work and grants copyright owners the right to enforce that prohibition. Bungie may prove its claim under Section 1201 by demonstrating Larson trafficked in a technology that is primarily designed, produced, or marketed, or has limited commercial use other than circumventing a technological measure that effectively controls access to a copyrighted work. Here, Bungie has provided allegations and evidence that Larson developed and designed the wallhacks cheat to circumvent Bungie's technological measures to protect its copyrighted works, and Bungie has shown that the wallhacks cheat circumvented the controls, and that Larson himself evaded those controls by opening new accounts after being banned. Additionally, Bungie has shown Larson violated 1201 by creating an infringing derivative work. The court finds that entry of default judgment on these claims is proper. The Computer Fraud and Abuse Act. The CFAA states that whoever intentionally accesses a computer without authorization or exceeds authorized access and thereby obtains information from any protected computer shall be punished by fine or imprisonment. The term protected computer refers to any computer used in or affecting interstate or foreign commerce or communication, effectively any computer connected to the internet, including servers. Bungie has provided sufficient allegations and evidence that Larson violated the CFAA when he intentionally accessed the Destiny 2 servers to obtain the Destiny 2 software to create the wallhacks cheat without authorization. By doing so, Larson violated the terms of the license agreement and manipulated key elements of the Destiny 2 software through the wallhacks cheat. Bungie has also provided evidence that Larson's efforts have caused it damage by requiring increased security measures. The court finds entry of default on these claims is proper. Breach of contract and interference with contract. Bungie must demonstrate that a contract imposes a duty, the duty is breached, and the breach proximately or legally causes it. A claim for tortious interference with a contractual relationship, a separate claim, requires 5 elements: the existence of a valid contractual relationship, defendant's knowledge of that relationship, intentional interference causing a breach, that defendants interfered for an improper purpose, and resultant damage. Intentional interference requires an improper objective or the use of wrongful means that in fact cause injury to the person's contractual relationship. Bungie has provided sufficient allegations and evidence that Larson breached the terms and tortiously interfered with Bungie's contractual relationship with other users. Bungie has shown Larson violated the terms of the agreement by accessing Destiny 2 and the underlying software to create the wallhacks cheat by creating multiple accounts after being banned. And by selling the wallhacks cheat to others, Larson induced others to violate the terms of the contract and interfere with Bungie's control of Destiny 2. And Bungie has shown that it suffered damages through this conduct by losing out on in-game revenue and expending substantial sums to combat the wallhacks cheat. The court finds entry of default proper here. On its CPA claim, the Washington Consumer Protection Act, Bungie must establish an unfair or deceptive act or practice occurring in trade or commerce, affecting the public interest, injury to a person's business or property, and causation. A claim under the Washington CPA may be predicated upon a per se violation of a statute, an act or practice that has the capacity to deceive substantial portions of the public, or an unfair or deceptive act or practice not regulated by statute, but in violation of public interest. The court remains unconvinced that Bungie has alleged a valid CPA claim. Specifically, it has not provided evidence of an unfair or deceptive act that had the capacity to deceive a substantial portion of the public. The wallhacks cheat was developed and sold as an express means to allow players to cheat in the Destiny 2 game. There are no cogent allegations or evidence that individuals who purchased the wallhacks cheat were deceived, or that they did not intend to purchase a cheat-enabling software. Bungie has not shown how this conduct caused it to suffer any injury. The court rejects Bungie's request for entry of default judgment on this claim. Civil conspiracy. A plaintiff must show 2 or more people combined to accomplish an unlawful purpose, or combined to accomplish a lawful purpose by unlawful means, and an agreement to accomplish the conspiracy. A claim for civil conspiracy must be predicated on a cognizable and separate underlying claim. The court finds that Bungie has sufficiently alleged a claim of civil conspiracy As explained above, Bungie has shown Larson conspired with Nelson and Schofius to unlawfully develop and sell the wallhex cheat. This is predicated on other cognizable claims explained above. The court finds entry of default proper. So, continuing with the idle factors. Given the substantial sums of money at stake, the court finds the substantial sum of money at stake factor favors entry of default judgment. The possibility of a dispute on the material facts, the court finds little possibility that these facts are in dispute. Larson failed to appear. Bungie has provided detailed evidence that's unlikely to be rebutted. Nelson consented to the entry of a judgment in a lot of these facts, which confirms the key allegations concerning Larson's liability. This factor favors entry of default judgment. Is the default due to excusable neglect? There is no evidence of such. Even Nelson avers that Larson was aware of the litigation but believed he was beyond the reach of the courts. This factor favors entry of default. And last, how about the public policy preferences? Larson's decision not to appear in this case vitiates against the policy of a decision on the merits and in favor of default judgment. So the judge grants the motion in part, and just not on the CPA claim, I think it was. And the total is not everything that they asked for. Instead, the court does not grant the full amount for the violations of the DMCA, just the $13,530,000. The judge is not going to grant actual damages. So we've got $13.5 million for the statutory violations of the DMCA, then another $300,000 instead of $466,000 for violations of the rest of the Copyright Act, the actual copyrights. Then the mitigation expenses, the weird $666,666 number. The court actually finds that number to be appropriate. The trebling or tripling is also appropriate, so the court enters it. $2 million. And then reasonable attorney's fees and costs, which the court grants. So the total default judgment is a little over $16 million. Then the court's going to grant injunctive relief. What does this mean? This means there will be a court order, and Bungie can parade this court order around and use the court order in whatever ways the court order is allowed to be used. And then if Larson further violates the court order, there will be further penalties without all of this trial stuff, at least not at this level of detail, because the court can just start with, did you violate the court order? So Larson and all persons acting under his direction or control and companies who receive actual notice must immediately and permanently cease and desist. They must not do all these things: create, distribute, advertise, market, etc., sell, resell, publish, distribute, operate, etc., the Destiny 2 software module, either alone or in conjunction, or any software which infringes on Bungie's intellectual property rights in Destiny 2, or violates the licensing agreement, or assists players to violate license agreement. They cannot invest or hold any financial interest in any enterprise, product, or company which he knows is going to do any of those things. And he cannot reverse engineer, decompile, packet, edit, or otherwise manipulate Destiny 2 without further authorization, or provide any assistance to any other person. The court further enjoins Larson and all third parties acting in concert with him from supporting or facilitating access to domain names, URLs, websites that further the violations of Destiny 2, etc. Larson's not allowed to use any social network to provide any content relating to the wallhex cheat. Further prohibited from violating the DMCA with respect to Bungie. He must destroy the Destiny 2 software module and any software that in any way interacts with Bungie's intellectual property. This will be a binding court order. Any company that Larson controls in the future must also comply. The permanent injunction is binding worldwide without regard to the territorial scope of the specific intellectual property rights asserted, and may be enforced in any court of competent jurisdiction wherever Larson or his assets may be found. Nothing contained in the injunction limits the right of Bungie to seek relief for any infringements occurring after the date of the injunction, and there is no reason to delay the entering of the default judgment and injunction, so it's entered. It's done. Larson owes over $16 million, and he's now enjoined as of the 9th of May. And that's Judge Tana Lynn, United States District Judge for the Western District of Washington at Seattle. So that's a remarkable situation. You make a cheat, you think you're just a guy on the internet having fun playing around with a video game and, you know, all the things that computers can do. And then it turns out you're in more of a legal situation where you agreed to a contract and now you're violating a contract and you're violating the rights of a multi-billion-dollar company who more or less knows how to come after you. Yeah, I've seen it before. I've represented people before. You've even seen some of them. And yeah, this happens if you do that. So yeah, don't violate the intellectual property rights of multi-billion-dollar companies. No, yeah, there's a legit conversation to be had about whether you're allowed to modify your games and such. At some level, you have the right to modify your games, to modify your car or your one-wheel skateboard, and then at some level you don't. And somewhere in there, there's also laws about whether other people can help you, how much they can help you, and whether it's a violation to sell or distribute tools that help people. And this is all really complicated. And offering something to modify your one wheel's settings might be one level of okay or not okay, you know, right on the line maybe, or there's a discussion to be had there at least. But making software to help people cheat at a massive multiplayer online video game, it's a little more clear of a violation, right? Like, okay, even if we couldn't find a written law that's violated, it's still some kind of unfair, right? Bungie makes a product, players buy the product to play the product, and then somebody else comes around and changes the terms on which people can play the product for only this subset, and they get to take advantage of everyone else. It's really unfair to the people who are playing the vanilla, unmodified, unhacked version of the game and paid full price for it and are expecting to have that experience. So it might be fun, it might be easy on some level for a software programmer or game developer or hacker to figure out what the vulnerabilities are in a game or whatever, but it is unethical and unfair for such a person to actually go and use those to injure players and injure a company that are not consenting to it. Yeah, okay, so maybe if you ran your own private server or something, if that was something you were allowed to do, and you ran your own private server and you made your own terms of your game and everything, that'd be fine. But if you're not allowed to do that, then you can't do that, and you therefore aren't legal if you make cheats for video games, and even less legal if you sell those cheats. Just being somewhere else on the globe, just being international, isn't going to stop Bungie if they wanted to pursue it. So maybe they'll drop it from here. I don't know if they'll further pursue Larson, but if you have a 16... is it 16? If you have a multi-million-dollar judgment against somebody, you might go after them even if they cross international borders. They might sell the judgment, the money judgment, to a law firm or collection agent that specializes in international collections. And then that firm gets a cut. So maybe if I recover 16 million for them, I get 1 million of it or something like that, or maybe even more. That's something that will motivate a collection agent to want to collect on that debt. Although I'm not sure that Larson has that much money. Maybe they do. And that would be something that Bungie would evaluate. Bungie and their attorneys would evaluate whether he's worth going after. Anyway, that's a real interesting case. Let me know what you think of that outcome. Because Larson didn't respond, they got a default judgment against them, and that included a RICO racketeering and corrupt organizations claim. Interesting. Let me know what you think in the comments below. If anybody needs me, I'll be exploring Hyrule.